engineering or humanities, social science, or any other arts or science kind of subject. And IP plays a very important, vital role in today's context, because it's very important for all of us. Because today, I think now the AICT area cell, they are organizing the 1 year celebration of National Education Policy. So that lecture is going on. Actually, I was part of that. We didn't know that it was our program was planned before, well before this.
Yes.
So anyway, so I request our director, because IIT Delhi director, IIT Kanpur, Kharagpur, all the big shots are there.
Yes.
So friends, without taking time, I'll just go into the slides, and we'll see what exactly IP, copyright, plagiarism, and all. So how much time will I get?
You can go up to 1 o'clock, Professor. Yeah.
Okay, fine. Okay. You can see my slide, right?
Yeah, your slides are visible and it is moving. Yes, sir.
Okay. So friends, very good morning to one and all. So I'm very happy and feel privileged to be part of this FDP program as a invitee speaker. Though your program is more on signal processing in 5G algorithm implementation, so it's okay. But IPR is very important for all of us. It is high time for us to learn about the IP rights, and what is our say on that. I mean, how best we can take care of the basically when you disseminate your publications, the research papers, you need to file a patent before you publish it. So anyway, I'll take you on the slides, and I will explain you in detail why IP is important in present context. Okay. So friends, you all are aware, the intellectual property was a Western concept, because we Indian, we are very happy to share our knowledge. We feel very happy in, providing the knowledge to all others, and we believe that sharing knowledge will increase the knowledge of oneself. But because of this, the global competition, because of this LPZ, this liberalization, privatization, and globalization. So the globe has become a village, and someone who invents something, obviously invention will not happen just like that. You have to invest your time, you have to invest resources, money, and everything, right? It's a value creation. So you have to protect your value. Otherwise, someone else will copy, someone else will take your value creation, and they will manufacture, and they will produce the product, and they will make more money out of this. So friends, so this background picture which I have kept here in this slide, these birds which are making nests. So it is very complicated thing. If you observe, it happens almost for a week to 15 days.
Sir,
to make
your
this nest.
slides are not moving.
No, I have not moved it.
Okay. Yeah. Just take
the earlier slide. Like.
Okay. Fine.
So I was talking about this slide. Okay. So friends, see, we since we are an intelligent animal, whatsoever, we always feel that human being is intelligent on planet. So that's the reason we have created a lot of things, right? But if you see the other side, if you see these tiny birds which are making the nest, it is not that easy to woven such a kind of nest. It's weaving this kind of nest requires a lot of effort, and that too, this this bird, they know they can predict the calamities and natural disasters which are going to happen. So there are so many species on the globe, on the universe, which have more knowledge than us. Okay, so anyway, so friends, for the day, we actually, a friend has given me the topic patents, intellectual property rights, copyrights, and plagiarism. So intellectual property rights itself takes care of, all the forms of intellectual property. So where we have patent, trademarks, copyright, GIs, industrial designs, integrated layout circuit design. So everything comes in intellectual, we call as intellectual property. And of course, copyright is also part of intellectual property. So intellectual property is broadly divided into industrial property and then copyrights. So plagiarism is something which comes with copyright. So I just briefly made the topic as IPRs and plagiarism. So friends, what is intellectual property management? How you manage your IP? That is very, very important, because these days you see all the old IITs like the 5 IIT, Delhi, Bombay, Kanpur, Kharagpur, Mumbai, and Chennai, along with the IISc Bangalore, they file at least 100 plus patents every year. Okay, so filing will, filing, after filing, you have a lot of things to do, you have to track your, patent application for examination, and then you have to respond to the queries given by the examiner from the patent office, and then after patent is granted, so generally it takes, 2 to 4 years. Earlier it took a lot of time, because that time we were not having the kind of infrastructure what we have today. If you see on, on Google, if you see the patent offices which are there in the 4 metros, they look like, not less than any corporate IT offices. So we have a state of the art infrastructure at place. So obviously the time has come down from, those days to almost 10 years in some of the patent, which, like for grant itself took 10 years, but now it ranges like, in immediate cases like coronavirus related research, within a year also will get the patent. So friends, IP management. So after getting the patent, you have to do the renewality, and then you have to maintain it, and then you have to leverage the IP whatever you have generated, because leveraging from where you get the return on investment of your intellectual property. So here I'll be covering what is IP and what is the use of IP, why one should have to know intellectual property, why do you want to protect your intellectual property, how to protect, where to protect, when to protect, to give the answer for why do you want to protect your intellectual property. I just wanted to hear from couple of participants. Why do you want to protect your intellectual property? Can anyone give me some input on this, friends?
Yeah. Let me. If someone would like to say something, raise your hand. I will enable your mic.
Yeah, they can enable their mic, and then they can.
Actually, I have taken control over that, since if all of them
start that time, then we'll have an echo.
Yeah, so there is one responsibility recognitive of effort. Yeah, I think Venkatesh Kumar would like to say something. Let me.
Please, Venkatesh, you please identify yourself, and then can tell me what you feel about. Yeah, very good morning.
Suppose if we are not submitting our IP or not claiming our research or any new product, it will be claimed by someone else. And again, sometimes researchers will give at claiming only the royalty. It will be given to the government of India, or it may be like it will be useful to the some other person also. That depends upon who has claimed that product.
Okay.
Based on that only, suppose for example, Kalam sir has invented that for handicapped people, that low weight. I didn't remember the name. Otherwise, it may not be useful to the people.
Okay,
Okay,
Venkatesh. So
I don't know
attempted. Yeah, well attempted. So friends, see, when you create something, it will not happen just like that, right? So you have to invest your time, your efforts, your money in the form of infrastructure development and everything, right? So everything, if you convert into price, in the value, so obviously you have to get return on investment. Whatever you invest, at least you have to recover. So you will only recover when you have a legal right on your value creation. So value creation is intellectual property. Of course, you create, you put your thoughts on that, and you develop a prototype and you make a workable model, and then obviously you will get a patent for that. You have to file a patent before you disclose this information to the public. See, public disclosure will, will make you to lose the novelty. So please never ever you disclose your information or the invention or the claims what exactly you feel, the novel thing. You keep with you and you only submit to the patent office in the form of drafting a patent document, and then after filing a patent, so let's say you have filed your patent today, tomorrow you can disclose to the public. Okay, because you have already filed a patent application, so you file first. So intellectual property is something which is like your other form of property. Like we have a mobile, right? So I have bought this mobile. So the mobile, when I buy this mobile, so all the details of this mobile, all the component details, everything is given in the form of, a receipt. And if I say I can lock this mobile, I can make it, as my property. And of course, since mobile is, it is only a software game where someone can change, the softwares and can do it. But in case of you take your four-wheeler or your two-wheeler, so every engine has an unique number. So that engine number is registered with your name. So you are the owner. So you go to the RTO office and you get it registered, right? So if someone the vehicle is theft, so someone thefts it, then you can file a complaint. Similarly, in intellectual property, let's say you have got a patent. So once the patent is given to you, if someone is infringing, you found that your claims, whatever you claimed, whatever value creation you have claimed in your patent document, is someone is infringing or someone is copying or someone is manufacturing a product out of this information, obviously you can file a case against them and you can prove it in the court of law and you will be paid the damages. So there are plenty of such cases were happened, in the recent past. If you say many academic institutions on the western side, if you take MIT files n number of patents. They have a very big office, their TL, we call the technology licensing office, where they have around 400 people works in that, right? So friends, here, so patent protection or the intellectual property, whatever you feel is a value creation, what you did. So value creation in the sense, friends, it should be novel globally. Globally, it should be novel. Nowhere such kind of things were in use. Nowhere the information is published. Maybe in the form of journal articles, form of magazines, anywhere it is quoted, or otherwise. Sometime what happens is the folklore, right? If you go to countryside, people they pass on the information, trade secret from one generation to another generation. This is also called as an intellectual property that becomes a trade secret. But if you feel like, in case of the traditional knowledge like haldi, basmati, kala jira, there are so many such traditional knowledge which were cultivated in India for ages together, were filed patent in USPTO, United State Patent and Trademark Office, where they don't have an information or the literature about this information, and they have given the patent to those people who filed, and most of them are Indians, the NRIs. But of course, after those patents were granted, but Government of India with the gave the task to CSIR, and CSIR collected a lot of information. Friends, you can search on web. There is a website called TKDL, Traditional Knowledge Digital Library. So almost 2 lakhs of all the slokas, books, and from Unani, Hasta, Siddha, all the homeopathy, Ayurveda, naturopathy. So from all those information were digitized and given that information to across the globe to the patent offices. Now the patent offices, whenever they receive any application, they perform a prior art search in the TKDL also. So after providing this information, all those patents which were given on the traditional knowledge of our country in elsewhere in US, Europe, Japan, Australia, all those patents were abandoned or revoked. Those patents are not now in force. They are revoked. So friends, the novelty should be the prime and it should be universal. So if you feel whatever you are doing, it is novel, you can go ahead with filing a patent application. So how to protect IP? So obviously, so we have a different form. So basically, most of us, science and engineering, we do invention. So invention falls under patents. So you can file a patent application of your jurisdiction. So basically, Goa comes under the western jurisdiction of the Mumbai Patent Office. So you have to file a patent office here in Mumbai. Okay, way to protect, when to protect, way to protect in the sense, so whenever you want to file a patent application, so let's say you and your IP team, so every institution like all IITs, they have an IPR cell, right? So there is a team of people who will be there in the cell, and let's say you are from electrical engineering, you have invented some invention, maybe you have made a integrated layout circuit design. So you apply to your Dean Research Office where they, I think the IP will be part of that. So they will evaluate, and if they feel, you all feel that this invention has a global market, the value that what you have created has a global market, the better you go for a PCT patent application. PCT is Patent Cooperation Treaty. Right, patent cooperation treaty. So we have a treaties and convention. What a treaty? Treaty is there are countries which are having some kind of problem in filing. Let's say for this, the one of the invention which I was telling, like the blockbuster invention which has a global market. So now if you want to protect this invention, say intellectual property is territorial. Let me give you the context. Intellectual property is territorial. If you file a patent in India, you will get protection only in India. So elsewhere, people are, if they are copying your invention and they are making, all that commercial activity, you don't have any right to stop those people. Only in Indian territory, you can stop them. You can stop, getting those products from elsewhere to India, importing, you can stop. You can inform to the customer, but this invention is a blockbuster. You wanted to protect globally, so you have to file patent application in every geography or every continent or every nation in every country. That was the whole thing. So to solve the problem of filing patent application in different countries, the World Intellectual Property Organization called WIPO, WIPO. Okay, you can search on web wipo.int international. So WIPO administered this PCT, Patent Cooperation Treaty. So now I think around 170 countries are part of PCT. So all these countries, India also member of PCT, Patent Cooperation Treaty. So in all these 170 countries, you will get the protection if you file only one application in your national phase, in your India, like, in our case, you can file one application in India, and then the Indian Patent Office will give you some time, I think 18 months to choose the countries among this pool of 170. So out of this 170, you want to protect in, let's say, European Union comprised of around 26-30 countries. So that will take up only one application for the European Union. So where I think UK is not part of that. And then you may choose UK, US, Australia, Japan. So all the developed or developing nations where you can expect a good protection for your intellectual property. After choosing this, you need to only pay the fee of those countries. No need to draft again your patent application. So only single draft, whatever you have done, even if you have done in your local language, maybe like in our case, so different southern states have a different language. They can file a application with your local language also. That will be taken care. Then coming to when to protect. So what is the right time to protect? So what happens, sometime, like the research fields like biotechnology, pharma, okay, chemical, and such kind of fields. The investment for doing R&D will be in millions of dollars, right? So if you feel like your invention is almost reaching the final stage, and you feel like your competitors also doing similar research, and if they file a patent before you, then whatever you have done is going to be in vain, because you also doing same research and someone else has filed a patent, so he will get the right. So tomorrow, even if you make an invention and you are not allowed to do the commercial activity with your invention, so you have a window called provisional application. So provisional application will give you a window of 6 months to file the final application. So basically in those fields where the investment comes with cost, people will go for filing a provisional application. Then friends, how to leverage? So obviously you have a lot of mechanisms, how you generate revenue out of your patented product or process. So you can go for licensing. So you have a different kind of licensing, and you can also, sell your patent at lump sum. You may start your own venture. IIT Bombay has a lot of ventures. Now the new education policy allows all the faculty across the country. They can have their own ventures. Now we can also, most of us who do a kind of invention while teaching and doing research in our organization, we can start our own venture with that invention. That is allowed now, right? So you can have like IIT Bombay, there are few faculty, they are having their ventures. They are, having their own companies. So then friends, we have a patent valuation. It is a very big topic. See, intellectual property itself is a very huge subject, in the sense is an ocean for me, because I know last almost from 2004 onwards, almost for 17-18 years, I am into this field. So each topic is itself is a subject for us, and I teach this subject for a semester for almost 45 hours. In NITIE Trichy, I was there for 5 years, so I taught 5 years. It takes one semester. So here in NITIE Mumbai, also teach. I'm teaching since 2013. So it's a one semester course. So valuation and all, I will not be going to touch. We have different valuation methods. So in future, if you require, we can have another session for this. The cost of protection of intellectual property. So there is a statutory cost for every country, every geography, territory on the globe. Each country, they have a statutory fee. Then there is another fee, which is your legal fee. So your lawyer will charge you. It all depends, okay, whom you are hiring. So IITs, all IITs, they have a panel of lawyers, and there's a fee is fixed. So you can choose any lawyer, and his fee is fixed. So patent drafting is very, very critical. Okay, you need to have a techno-legal language there to draft your claims and everything, right? So that's where the lawyer fee comes into picture. So here in our country, there are lawyers, who who can draft, who have a knowledge of drafting patent application, will charge you a minimum of 30,000 or 30,000 to 2 lakhs. We have a, a top firm called Anand and Anand. They are the pioneer in IP area in the country. So they will charge you huge. It all depends, okay, how your invention is valuable, so it all depends on that. So if you are targeting, countries like USA will cost you $100,000, okay, because it also covers the maintenance for the next 20 years also. So everything including that, it will cost you $100,000. So you have to make sure that your invention will generate that much of revenue. Enforcing IP rights. So you are the one who will be going to enforce, in the sense, in case of infringement, you have to police and you have to give the information to the court, and court will take care of putting the appropriate the damages, claiming and everything will be taken care by the court. But of course you will be claiming that this is the damage happened to your patent because of this, so you want this much of penalty from the infringer, so court will do that. So what are the things you can protect under intellectual property, we'll see. And who owns IP? In all of us, our case, all of us are academicians and we are working with some organizations. So either it is government or private. So obviously our organization is the owner, but there is a small scope here for the inventor to become owner. So when you won't use the significant, again I'm telling, significant usage of institute resources. So if you are not using significant usage of institute resources, then institute will not claim the ownership and you will be the owner of that particular IP. So friends, again I'm telling you, like if you see, you can search on web about the IP policy of most of the world IITs. All world IITs, they have IP policy. My institute, NITIE, also we have IP policy. I only drafted IP policy of NITIE. So in IP policy, we have defined everything. What is significant usage? What is the procedure for filing a patent? How you go filing a patent in your own organization? What is the procedure? And everything is drafted there. Okay. So that itself is again a policy, and it takes another 1 hour to explain. So that I am not going to cover here, but your ownership will be taken care by the IP policy. Even in the revenue generation, let's say your invention has got commercialized and the institute is making lakhs of rupees in the form of royalty. In that case, what is the institute share and what is the inventor share? That is also drafted everything in the IP policy. So IP policy will be a guide for that. Okay, and the protection for different forms of IP, I'll explain you while I'll be taking to the those forms. So friends, let me also give you why IP is important. So I have already explained all this. So maintain competitive advantage, protect your R&D, protect your R&D investment. Okay, attract investors, defend your company, protect your brand, use collateral to securing finance. So the way we get the loans, loans for constructing house or buying your vehicle or any property, you always put collateral as your land, buildings, or any other property. Similarly, you can also put your patent as a collateral. Of course, in India it is not a happening thing, but elsewhere in the Western world, obviously, there are banks will give you a lot of loans on your intellectual property. So in our case, I think there was a couple of things were happening. Of course, when you talk about the Kingfisher Airlines, Vijay Mallya has took a lot of money based on the brand value of Kingfisher. So at that point in time, the evaluation team has shown the brand value was in multi 1,000 crores, and he took a lot of money from the banks. So that was the classic case which was happened. But otherwise, the collateral is given I mean, collateral, it is taken as a collateral for financing, patent. So investor, attracting investors. So whenever you see in the recent past, what is happening in the country, so all the academic institutions, the premier institutions, where students are developing startups, you have incubation startups and everything. So in the last almost for 3-4 years, the government of India is also stressing more on the startups and incubations and new ventures, right? The startup, the investors, we call them a venture capitalists or angel investor, whosoever, maybe individual banks or financial institution. They will only invest in your company when they feel, find that there is a value in your business proposal or in your, product or process, whatever you're going to market or whatever you're going to commercialize in the marketplace. So value creation is very, very important here. So you create value. Basically, in entrepreneurship, we say, you chase, in creating value creation, you chase for that, and money will automatically chase you. So you basically going to spend your time only on the value creation. Don't think about money. If you are thinking about money, you never create the value. If you create value, money will automatically flow. So IP creation, IP is the only way where you can generate a lot of revenue. So we might have seen in the last 15 years, you take a decade now. So we have Ola, Uber, Flipkart, Amazon. You take all these e-commerce ventures, right? All those e-commerce ventures are the value creations. Flipkart was sold for how much? Maybe around 19 or 20 billion US dollar to Walmart. See the kind of money generated through one venture in no time. I think 1 decade is not a big time. It's more than 1 lakh crores of Indian currency. You have Oyo, Ola, Uber and all. See, Oyo, they don't own a room as such, but globally they are having a big business like Airbnb. It's a very big company today, right? So friends, then you always go for non-disclosure agreement whenever you share your information with others. Then so as I have already explained, you don't publish. If you publish, your invention novelty is lost. So don't make anything which you feel is novel, which you feel is a creation of value, which you feel is a novel claim. Keep with you till you file a patent application. You file a patent application and then you can speak loudly in the open forums. You can write an article. You can do anything. But before filing the patent, if you share your information in any public forum, you will not get the patent because patent office will examine only the novelty and the inventive step. I will explain you what is inventive step in the coming slides. So publish and perish. Now it is publish and perish. You will not make anything except saying that I have a publication maybe in A or A star and it may help you in getting the next level in the ladder. That's it. So now it is patent, publish and flourish. So you go for patenting and then you publish, and then obviously once it is published, then everyone comes to know on the globe that in that particular research area that you have done a research and you are the owner of that intellectual property, and they will come to you and take the license and you will become a millionaire in no time. Provisional application I have already explained. Security of data, I don't want to stress more on this because see, data security is also very, very important these days. So whenever you are becoming an X, in the sense you have worked with a company and you left this company and you have started working with another company, or you might have started your own venture, but you are not supposed to use the data of your old company. So old company data is already, they have a records and everything. And if you are using even the customer database of the old company also, you are not supposed to use. That becomes an infringement. So in recent past, there were a couple of companies which have filed a case against their ex-employees and they won the case. So friends, be careful about using the information of your previous companies. So, friends, can someone give me the definition for the invention? I just wanted to hear from one of you the definition for the invention.
It is just like a breakthrough in a particular tech field or technology. A breakthrough, sir.
Okay, the breakthrough is an invention. Can you give me an example? Any example? Actually, I'm playing on full screen mode, right? So I could not see, who is talking and whom I can call. I can see. I mean, I could not see that. Someone is raising the hand. I could not see here. So please. Otherwise, Professor Neelkannan can help me out.
Yeah. Whomsoever raising their hand, I am enabling them to speak.
So it is something like which was not there previously.
I wanted
to something new to the new thing. Okay, which has been not done previously.
Please, one example. Can you give me the example, please?
Sir, for a small example, okay, 5G, sir. Previously, okay, there was we had 4G. Then the next invention is 5G.
Okay, so now you tell me what is 5G? What is the novel thing in this? In 4G, we have seen a lot of things. So, in 5G, what is the novel or a new thing which made it as called as 5G?
The main more data rate and more that is supporting time critical applications and massive machine type communication. So this was these are all new that is characteristics of 5G.
Very good. So when you convert all these into a device, like this mobile, it's obviously we are using the 5G and everything. It actually comes with the mobile, right? So those features, when I use those features, those things are tangible for me, right? Tangible. So I can touch this product, I can touch this mobile, I can use those features. I can get the tangible output, right? So that tangible output is this tangible product or tangible output is called as something. And because this tangible output and also I know, okay, how to operate this, how to operate in the sense I can click on a particular button. If I swipe it, then my screen comes with it asks me the lock, the key numbers in the password. So when I use the password, it opens. So these things I know, but how these things are happening, the background, those algorithms and all, that I don't know. That is know why these things are working. I know how is something I can switch on, so my AC will work. I can off the switch, my lights will go off. That is know how. But why when I am clicking, putting a switch, I'm offing, oning. I mean, when I on the switch, the lights are illuminating. But what makes the light to illuminate? What is the method behind this? What is the process? What is the algorithm? What are the calculations? What are the mathematical? Those things are know why. So in invention, basically, so know why is I mean I could not see those things, right? Those things are intangible. So intangible is something you cannot touch it. You may feel it. I can read, I can read the algorithm. I can see the calculation. I can read the formula. But I cannot, touch them unless I convert them into a tangible final product, a tangible form of those services. So invention is more often called it as an intangible form of your intellectual property. So all these 5G features, what you have explained now, so those things are inventions, intangibles. So once you, in this mobile, there may be more than 1000 patents. Those 1000 intangibles, invention makes this final product called as innovation. This is a tangible form of the inventions, 1000 inventions, 1000 plus inventions. So friends, invention is, as I said now, it is an intangible form of your intellectual property. So various tools, techniques, algorithms, all the wireless technology, or even why this touch screen, how it is working, when I am swiping, how this glass is working, what is there behind that? Because I have a glass on my table, so this, if I do something, it will not work here, right? So in this screen, there are some inventions which enables when I swipe it, so that screen opens, right? So that is know why. It is called know why. That is the invention. So invention is an intangible form of your intellectual property. It is called as know why. If you know why it is working like that, if you know that knowledge, that is invention. Then, yeah, I have already explained you. So innovation is, so more often, most of us we are using invention and innovation as a synonym, right? Interchangeably we use. That is very, very wrong. Invention is intangible form of your intellectual property. It is called as know-why. We have know-how, know-why, right? Know-how. So I know how it is working. So how to make it work. So I just swipe it. So it is know-how, and I have made a final tangible product. Final tangible product which is available in the market is called as innovation. So there is a lot of difference, between invention and innovation. So we define innovation as invention plus commercialization. So here a tangible form of product. So if you talk about the the vaccination what we had recently. So I hope most of you might have had your first round of vaccination, and some of you might have already covered your second round. So Covishield vaccine is a innovation. The solution inside that Covishield, that small bottle. Okay, that solution which contains different elements in different proportion, that is invention. When you bring it, mix it, and make a final product tangible, which we can use it, that is innovation. So all that goes in, all those elements, the chemicals which make the final product, those chemical formulas, names and all, that is invention. So I hope you have understood the difference between invention and innovation. If you have any doubt, you please ask me now. Anyone has any doubt about the invention and innovation, and what is tangible and what is intangible, what is know-how and what is know-why? If you have any doubt, please ask me now.
Sir, so IP is an invention or innovation?
See, the patent is invention.
Okay.
You convert that patent into a product, that is innovation. So your patent is intangible. So whatever you have written in that, it is intangible. What is tangible and what is intangible? Tangible is something which you can touch and you can feel, right? Intangible is, it's a intellectual thing, right? You have just written some formula, some algorithm. Those are intangibles. Your final output of your intangible is a tangible product, right? So your patent. So this mobile has more than 1000 patents. All those patents are intangibles, but the final product is tangible. This is innovation. Innovation is tangible form of your intellectual property. Invention is intangible form of your intellectual property. Is it clear?
Yeah, yes, yeah.
Yeah, great. So I have kept here the ring pull technology, the Coke can, you know, this ring pull. That was an invention. You know, this invention was made by a school dropout, and overnight he has become millionaire. Because this ring pull, I mean, in the recent past, we might have seen, in the last couple of decades, we have seen this, right? Ring pull. And the kind of material which is used here, it will not be that easy to, you know, get removed, itself. And at the same time, it will be very easy for someone to open it. It cannot get opened self, right? It will be, takes care of the material inside, you know. So this ring pull technology, this guy has licensed, gave a non-exclusive license to all those bottling companies across the globe, and he charged 1 penny per can opened. That was his royalty. And globally 2 million cans were opened a day. Opened in the sense, he said it is the cans manufactured. So globally there are 2 million cans are manufactured in a day. So 2 million pennies is almost 20,000 US dollars. And you in a year into 365 into 20 years. So you may make almost 150 million US dollars. That is the value of intellectual property. The moment these companies have signed an agreement with this guy, all those banks were after him to give him loan for buying, Benz, Bugatti, Ferrari, and having to, to have his own bungalows and all. That's the intellectual property part. See, we all, if we are working the way we are, want to be, just teaching and taking care of our job, you will never become your lifetime a millionaire. In dollars terms, I am talking about $1 million owner. But if you invest your intellectual property in solving the problem of the society and creating a value, in no time you will become a billionaire. See the Flipkart guys, one of the guy, Bansal, we used to stay, we both are used to stay in same hostel in IIT Delhi called Kumau. He was doing MTech and I was doing PhD. Today he's a billionaire. Okay, I'm a teacher. So that's the difference. So friends, I just wanted to know what leads or what are the inputs you require? What are the functions to make an invention? So I have already given you the definition of invention, right? So what inputs you require? What prompts you? What makes you? What leads you to create an invention? Now it is open full floor to give me the inputs for this. How do you create an invention? What do you require actually? What catalyst you require? What kind of things you require? Please help me, friends.
Creativity, sir.
Great. Well done. So, what's your name?
Venkatesh.
Venkatesh from?
Krishna Institutions, Coimbatore.
Oh, great. Great, Venkatesh. I need at least half a dozen inputs for this. So, creativity is one of them. See,
another input from other.
Sorry?
Yeah. No, there is another input from one of the participants,
Yep.
Ravi, a burning problem.
Burning problem. Okay, that is ideation. Okay. Burning problem is an ideation or it is a necessity. We all know, most of us have heard this saying, necessity is the mother of invention, right?
Yeah.
Covishield, Covaxin, these all are necessity outputs in recent past. Mask and everything. See, mask was also a necessity. So mobile, yeah, your 4G, 5G, whatever, mobile has become a necessity. See, once upon a time, it's when the mobile technology was started. See, wireless technology was there in on the globe for many years, right? It was basically used only in the defense, right?
Yes.
But
Yes.
when in 2090, early 90s, 94, 95, we had the first mobile company which was started this. We had a walkie-talkie mobile, right? I used to see
Exactly.
with my
Yeah.
my research guide, you know, he actually he was not not to I mean he was not in a position to offer because at that time it was costing 25,000 in early 90s. That is a big amount, right? So he brought from a project looks like, and he used to carry that in all the forums, and people will see it, that walkie-talkie. Uh, Today, if you see the mobile, the value, our evaluation of mobile from walkie-talkie to this, smart mobiles, how much of change was happened? Like from walkie-talkie to the Nokia slim mobiles, 2200 and all into early 2000. It took almost 10 years to reach to that stage. And walkie-talkie mobile was costing 25,000. The another side, you have to pay for making calls and receiving calls. That is very troublesome, for many of us. And of course, most of us have witnessed, how those queues were there in front of those telephone booths, for making calls, right? We have a 1 rupee coin continuously for 60 minutes, it will come. So the moment touches 50, we'll put another coin. So from where, how the technology has changed us, mobile. And that time, mobile was a luxury product, right? Only, I think 4 to 5% of the total population were having mobile. When the mobile has reached to the common man, now the value has gone. Like, I mean, the luxury value has become a common value now. So it is a necessity product today. So friends, without taking much time, so these are some of the things which you required for creating an invention. So you need ingenuity, imagination, vision, necessity, creativity, conception, opportunity, ideation, originality. So all this will lead all of us who do research, either science and engineering or in arts, or even someone who is making a art, painting or drawing or whatever. So for everything you need some kind of input, that is in the form of all these variables which I have given, right? So friends, can someone define what are the different properties we have today? Broadly. One way we were talking last
Our
1 hour, we were
ideas.
discussing about that, right? That is intangible form of property, that is intellectual property. How many of you own a two-wheeler or four-wheeler, or a house, or a land? These all are property, right? So that is called, we call them as a traditional property. When I differentiate with the intellectual property, I call them as traditional property. Okay. So natural resources also are property, right? So intellectual property, whatever we are witnessing these days, all that whatever we publish, whatever we are using, all those products which are unnatural, I'm keeping unnatural creations, whatever is naturally occurring on the universe, in the globe, are not patentable. Those are the properties, maybe in the traditional property that may come. Someone, discovers a planet, a new planet. It is not a patent, it is a discovery. Discoveries are not patentable. And of course, to give the credit to the discoverer, you may name that planet after his name. So I'm just giving you a couple of pictures here. There is one picture which already displayed. Can anyone tell me what is happening here? Come on, friends. I need more energy from your side.
Please raise your hand if you like to say something.
What do you infer from this picture?
Ranjan, already you are enabled. Please speak.
Yeah, I think the mentor is trying to, targeting, and the other students are observing that how the arrow is going to hit the target.
So who is mentor here?
The person who is just behind means a
What is
long
his
beard,
name?
means Rishi, we can say. The Guru and Rishi. Yeah.
No,
This is part of Mahabharata.
Oh,
You might be knowing Mahabharata story.
yeah, as per the epic, yeah.
So Dronacharya was the teacher here, and the guy who is targeting with the arrow is Arjuna, right?
Yes, sir.
This picture is another story during the same time, that time period. I think you will get more clarity here.
Okay. So it's a Guru Shishya Parampara kind of thing.
You know
Or
Eklavya? You know Eklavya?
yes.
So he is the Eklavya who is giving right thumb to his guru as a Guru Dakshin. The guru is Dronacharya. So Dronacharya wanted Arjuna to be number one in archery on the globe. Okay, on the other side, the poor son of tribal king Eklavya, who learned archery, himself, he learned on his own, of course. Dronacharya didn't teach him every day. But this guy, he has made an effigy of Dronacharya with mud, and then every day he used to practice. And the day he reached the mastery in the archery, and he went back and showed to Dronacharya that I have learned now everything because of your blessings. So I wanted to give the Guru Dakshin. So Dronacharya was shocked, and Eklavya was almost crushed Arjuna in archery. And Dronacharya took a oath that he will make Arjuna as number one on the globe. So to protect his intellectual property, he asked the right thumb. Right thumb is key in practicing archery, right?
But this is impartial. Nah? Just you told me that the things which come in natural fashion, that will be considered. Means, for example, if a child is born in a natural fashion, can't we say that this is our child? Means the अगर बच्चा पैदा हो गया इसका मतलब हमारा उसके ऊपर कोई अधिकार ही नहीं है.
हाँ, ये ऐसा चीज है पुराना जमाना में then where there was no legal system, nothing was there. People are they give value to what they say. So when Dronacharya asked write them without thinking about the second thought, it simply gave the thumb. That is what the Rajaniti and everything. But that other side, of course, this is very politicizing. It's a discrimination. Huh?
This is a
So,
pure case of discrimination, I think, because if
so, so
because
anyway, friends,
to
see, I'm not going to hurt anyone here. I'm just giving a simple example how things would happen. Okay. Similarly, you can see this one also. So Shahjahan was chopped the hands of all those architects and engineers who built Taj Mahal, because he don't want a similar kind of monument will come somewhere else. These guys will go and they will build with some other king. Then the value or the image or the fame of Taj Mahal will go down, will go into drain. So this is unlawful way of protecting your intellectual property. So anyway, friends, the IP management is basically the function of three things. Can anyone tell me what is C, what is P, what is L? I have already explained with the pictures here on the bottom. Can anyone tell me what is C?
concept,
Then P?
protection,
Very good. Well said. So it is creation, protection, and leveraging. You create. The moment you create, don't publish. You protect. Protection is the legal right. Then you, after protection, you leverage it. You transfer your technology. You license your technology. The know why. Know why, that's what know how and know why. So know why more often they keep with them as a annual maintenance, what you call AMC, annual maintenance charges, whatever you call, right? So broadly we have different forms of intellectual property that we named as patent, trademark, industrial design, plant varieties, copyright, geographical indication. So layout design of integrated circuits. So most of you might have, I mean, the last couple of days might be witnessing what is integrated circuit layout design, which is the key for making the final product. Then you have a confidential information or the trade secret. Then the other side also kept one thing is traditional knowledge, which I have already explained briefly. So friends, broadly we can differentiate the intellectual property into two categories. One is industrial property, another is copyright and related rights, right? So under industrial property we have patent, trademark, GI, industrial designs, farmers, breeders' rights. So copyright related rights, basically it's a bundle of right? So literary or complete literary. Now we are using our computers, right? So though we are using fingers, when you write also use fingers. So we are just typing. So everything, whatever you type, the algorithms, you write novels, books, magazines, publications, everything, the literary work. Then we have a artistic work. So artistic works, we see, paintings, drawings, dancing, miming. There are a lot of things which are artistic. We have computer program. Friends, most of you are with electrical electronic background, I hope, because it's the conference is, meant for those kind of background. So all the computer program per se is copyright. If your computer program, whatever you invent, it needs a novel hardware to work. So together you will get the patent. But otherwise, globally, the softwares are under copyright, except USA. You may get software patents there, but rest of the world you will have only copyright. Okay, because your software programs all are algorithms, right? So mathematical equations. So those things become copyright. Then the complete electronic databases, all the websites, whatever data we have, now we call about the big data. Okay, that everything comes under copyright. So let's talk about the patent. So I hope few of you might have filed patent or might be having patent with you, might have an inventor in one of the patents. So what is patent? Can anyone tell me what is patent? Please, we are running short of time, and I have not covered even 1/4 of the slides what I have kept for this class. What is patent?
Yeah, Ranjan, please go ahead.
Yeah, any new thing and any novel expressions or something which we, researched during our study. If we want to reserve it and under the Copyright Act, then it is called as patent.
Friends,
Or
Okay.
actually, sir, there is a big confusion because the last year I have published one of my paper, and that was in Australian Journal, right? And
Okay.
after in this year itself, I am from the same Australian government. I am getting a mail regarding to file the patent for that publication. So in India, there is a controversy, means there is a contrast that once your any paper has been published, that cannot be taken as the for the patent. So, could you please enlighten us that means
This
how to handle such kind of
very
situations?
yeah, friend. What's your name?
My name is Anand, sir. Anand
Yeah,
Ranjan.
Anand, a very good question. So I am very happy that the government of Australia is asking you to file a patent. So see the publication what you have filed, they feel that the know why is still there with you. They feel you have not disclosed the complete information of your invention in the publication. That is what their feeling is. Okay, if you are claiming the thing which you have published in your publication, then you will not get the patent anywhere on the globe. Leave about Australia, even Australia also.
Sir,
Their
please
feeling is
repeat that.
that you have not disclosed all those information which makes the invention. That is what their feeling is. If you are going to disclose only those things which you have published in your paper, then you will not get patent even in Australia. Novelty is globally, it is the same rule applicable Australia or any other country. If the if the patent is given for those already published thing, then I mean you will not get protection elsewhere. If Australia, I am sure they will not give you the patent unless you prove the novelty. Your publication, what I feel is their gut feeling is that you have not disclosed the complete invention in your publication. You may feel still you have some of the claims which have kept secret as know why. See, we generally give know how. Know how is okay, but know why is more very important. That is qualifies your patent. And you said
And
copyright.
one,
Copyright is completely
one,
different.
and one more thing I want to add that once that mail was getting in my mailbox, immediately some office in India also they are trying to approach me that yes, you have to give the your all details and all, and we are charging nominal charges are there, means around 30 K and all, and we will help you out in for filing the patents. And so what is all these things? It's
Yeah,
a
yeah,
very
no,
confusing and feel unprotective during such with these mails and all.
yeah, friend. Don't respond to those mails unless if you see the domain name of that email is a government entity. Okay, let's say if you are receiving mail from patentoffice.nic.in, then it is authentic. There are a lot of doubts today in the market. They are using like in a day if you see I mean in your Google like I mean spam mail, there may be 10-15 lotteries where you have won some thousands of pounds. Okay, there may be messages. I every day I receive at least 10-15 messages. I receive more than 20 mails in my different mailbox, so I keep always them into the junk. Unless you receive your email from a domain name I am again telling you like iit.ac.in, IITB, IIT Bombay, IITG, IIT Goa, something like that. If you come with that kind of authentic domain name, then you respond, then you can spend your time, but otherwise
Can
those
I
all are
can I
phishing.
can I at this platform I can I share the website which they means this is
You
www.ideas2ipr.com.
Yeah, that is a private company. We have this many private companies, lakhs of like your hair. Those many private people are there. There are a lot of private agents. They simply want to make money out of because you are very innocent. You know the how many. See, they will send you that I have read your paper somewhere and we are very happy that you are doing very good research. You please send your other papers. We will publish it. But our publication charge is only 2,500. These are only money making business, nothing else. Don't give damn to those kind of mails. You know better,
Okay,
yeah.
sir.
We all are intellectual. We have
See, the
all
thing
our
is,
degrees.
because the same Australian government patent was, taken by a few of my known friends, and they shared it on Facebook and all, and very happy to share those information. And their universities are also getting recognized that yes, you have filed one patent in Australia and all. That's why I am a little bit eager about, and that it's a very means from this on this platform. I am really very happy to listen this kind of word from your side that this is not at all
No,
authentic patent
yeah.
filing and all.
There are a lot
Yeah.
of lot of phishing mails you will be getting. Lot of touts are there, and people want to mislead you. So please, unless you receive a mail from authentic source, so I can again, I mean, stressing you authentic source. So Government of India, if it is comes with the Government of India, then you can also copy that, domain name and paste in Google and search that website, who is running this, who are behind this, whether it is government, is private. If it is private, just come, I mean, just give a damn for that. Don't spend your time, don't waste your time, don't waste your money. It is simply waste of your money and time. You will be
So
trapped.
what is the procedure to file the patent in India? Can you please give some
Yeah, filing a
steps
patent,
and
basically, see, you go on, like, see, generally what happens for the patent office to manage, everything, they have patent agents. So patent agents are notified by the patent office. Every year, patent office conducts the patent agent exam twice in a year. So all of us, those who are having science or engineering graduation, we all are eligible to write that patent agent exam, and you will get a patent agent number. And once you have a number with that number, you can file patent for yourself on behalf of others also, right? So that is the entry for filing a patent. So most of the organizations, like say the academic institutions in the country like IITs or NITs or premier institutions, we all have a panel of patent lawyers. So all those lawyers, they have a patent agents with them. They either they are themselves patent agent or they have recruited patent agent to work in their firm. So they file on our behalf. Okay, if you are interested, you can write it. It's a very easy exam. I mean, of course, you need to know basics of the intellectual property. That's what is asked in that. Okay, you need to know the international treaties, conventions, through which you can file patent in different geographies. What is copyright? What is Berne Convention? There's a lot of things you need to learn. Of course, the patent agent will not charge you much, but the patent agent is the one who is a catalyst in this complete process. He will, through whom the patent office informs you everything, the happenings with respect to your patent. You just file a patent application, but drafting of patent application is key. I have already explained. So where you need to draft your claims in a strategic techno-legal language, right? That is very, very critical. And then you file. But
in simple manner, we cannot directly file the patent. We required some means we have
you
to
can
go through
see
some
you
agent.
can
Yeah.
see you can draft your patent application your own. There is no problem. There are many people in CSIR lab, the scientists, they know more. Once you file 2 3 applications with somebody's help, later on you become master in filing. But for filing you need a patent agent, number. So you can, I mean, there's a list is already available on the web. You can search. Otherwise, also in your locality, there will be someone who is having a patent agent qualified, having a number through whom you can draft yourself. You can file it. But the thing what happens here is when the patent examination does the examination, your claims may become novel, not novel, maybe becomes obvious known thing, then you may lose getting a patent. So patent writing is also tricky. There are, in some time back, there were paper called as paper patent. So what are the paper patent? The guys who, having a lot of knowledge sit together and then they do a lot of literature review. From the literature review, identify some gap. In that gap, they file a patent application as if they have invented something. Okay, they claim that this is something we have invented and they get the patent. This is called as a paper patent. Now the patent office requires even your lab reports, information, everything. If you give those kind of support, then you will get patent in no time. But novelty is very, very critical. Don't look at someone is sending a mail that you have published a patent in Australia, so will protect you, pay us something. Once you pay it,
Okay.
they will not lift your phone call, they will not reply to your mail. You will be
Yeah,
trapped.
okay, sir. Thank you so much, sir. Thank you.
Yeah. So friends, patent is monopoly right. As an inventor or the organization who owns the ownership will have a monopoly right for 20 years, right? So not exactly monopoly, but you are exercising your patent. The moment you file a patent and you feel that this patent is like the Covishield, Covaxin, we have something which is going to take care of the necessity of the public. In case of life-saving drugs and all. If you are not commercializing, if you are not making the product available in the market, then government has a special right called as margin right. So the government can call somebody else who is having similar kind of business, can tell them that you manufacture this product and bring into the market. So you don't have any right to stop the government. So it is called as compulsory license. Okay. So if it goes to the compulsory license, then you are no more a monopoly. But of course, being an inventor, owner of that invention, government fixes some royalty for you. It ranges from 3 to 6%, and you will get only that much of royalty on the sales revenue. So we have a 1970 Patent Act which has amended in 2005. Why it was went for amendment in 1970? That is again a big story. Not story, it's a reality. That will take another 1 hour for me. So you can read on web. Friends, all the acts are available on the web freely. You can download them and you can read them. There is no copyright violation in that kind of documents. So terms of protection is 20 years from date of filing. Right? So what is patentability? How do you get the patent? What is patentable? Where do you get the patent? So these are the questions most of us will have, right? So you have already asked how to file a patent. So what is patentability? I have already explained one of the conditions, right? So novelty is core, So invention not known to public prior to claim by the inventor. So when I am claiming today, yesterday should not someone say that I know this, or before that. In the past, no one should know about this. There should not be any information about this claim, what I am claiming. Then it is called novel. Then novelty will not suffice for patentability, because so let's say I have a glass of water. So in the glass of water, I have added 2 spoons of salt. So you tell me the salt, saltiness. I have 500 ml of water, and if I add 2 spoons of water, so it may not be that much salty. It is okay, right? So it is, let's say it is, no one knows that I have prepared salt, and I mean, let's say it's a history, it was happened, that point in time it was novel. Let's say in the same, after, some time it has become, everyone knows that when you add, any chemical, so that will exhibit that property proportionally, right? So I add 10 spoons of, salt in the glass, and if I taste it, obviously the saltiness goes up. That is obvious. So I'll say, I'll tell them that it is an efficiency I'm talking about. So efficiency has gone up. If you take, paracetamol 500 mg instead of the take paracetamol 600 mg, the efficiency goes up. But that will not give you the novelty. That is obvious. So you should have to show the inventive step also. So it is called inventive step or non-obviousness. So how do you measure inventive step or non-obviousness? So people who are having similar skill in the art should say that this is not obvious. So your invention is in biotechnology. So biotechnologists say that it is not obvious. If it is in chemical science, chemical engineers say, it is in electronics, anything. any field. So those people who are having ordinary skills in that particular art should say, this is not obvious. Let's say we all know 2 plus 2 is 4. But I say 2 plus 2 is 22. That is non-obvious. 2 plus 2 is 22 is not obvious. It is non-obvious. There might be something behind this which makes 2 plus 2 is equal to 22. So you should have a inventive step, novelty and inventive step. And the third condition is industrial application. So of course, whatever we make, more often will have an application in the industry. There will be a use for that. If your invention meets these three conditions, then you will get the patent. So, Professor Nilkanda is 1 o'clock now. I could not cover 15% of what I was meant for this. So I have, I think, almost 114 slides. We have covered only 16 slides. I need at least couple of days to complete the intellectual property. But anyway, friends, it was a very interesting discussion from your end. So I feel privileged, and hopefully, maybe if required, we can have an maybe a day-long workshop separately for your faculty who are doing this, because it's very, very important. I'm also planning to get a a project from ICSR for capacity building workshop. There, hopefully, if it is online, I can have at least 500 people. So recently in the faculty development program, my topic was IPR only. So we had 200 people because now they kept the cap, right? So friends, any of you have any doubt, you can reach me out. My email ID is here, and you can also search on web. My institute name is National Institute of Industrial Engineering. So NITIE Mumbai is started along with IIT Bombay. It is the only institute in our country which offers exclusive industrial engineering PGs. We have a post-graduation program, MTech and MBA. And people who won't make to NITIE will get admission in very next IIT Bombay or any other IIT. So for the industrial engineering program, NITIE is the #1 in Asia. And to give some information, the last 3-4 years, students are coming from all the IITs. After doing one MTech there, they are joining for another MTech here, because we have a placement record of 100%, and our packages are average is 20 plus lakhs. The last year also we had a 100% placement. So some of our second year students who did their summer internship in different companies. So as on today, out of 500 students, we have got 150 pre-placement offers. In summer internship itself, the companies have announced their placement for the next year. So out of them, I think Amazon has given offer for 25 students. Their package is almost around 30 lakh per annum. So friends, NITIE is the place for all those students who have done engineering. So our entry is only for the BTech students, engineering students. So it's all about NITIE, and most of the heads of the operation, supply chain, logistic departments of all those MNCs are NITIEans. So I'm very happy to be part of this institute. So thank you, Professor Neelakandan, for giving me the opportunity, and hopefully we'll connect with you in near future. Thank you everyone, and have a great day ahead.
Yeah, it's our pleasure. Thank you very much, sir. Thank you very much.
Thank you. Good day. Good day.
Thank you. Okay, participants, we will meet at 2 o'clock again.